The timing of Judge Young's decision couldn't be more exquisite, coming on the heels of Donald Trump's attempt to crush First Amendment speech in America. And now we've got an opinion by Judge Young. I don't know what's more breathtaking about it. The fact that he started the opinion with responding to an anonymous postcard about what does the federal courts have that Donald Trump doesn't have. And when I read to you that postcard, you're going to know all you need to know about this decision. This was about student groups and professors on campuses, including all permanent residents, all having proper immigration status, but Donald Trump crushing their First Amendment expression, in this case against the Israel-Hamas conflict on the Hamas side. That under the false flag of that all debate is anti-Semitic, they then went after, methodically, one after another, student leaders and professors and had them removed from the country under orders of Marco Rubio. This chilling impact on the First Amendment cannot stand, Judge Young says, a Reagan appointee in the senior status up in Massachusetts. In fact, as I said at the top of this hot take, I don't know what's more remarkable. His response to a postcard that he had published above the caption, or the last 5 pages where he talks about the First Amendment and Trump in America, wasn't really necessary for his analysis, but certainly he's speaking to a broader audience, the United States Supreme Court, to history, and of course to this audience. Let's get to it. I'm Michael Popak. You're on the MeidasTouch Network. The postcard that was left in chambers for the judge, which we never knew about, but has now been reproduced by the judge on the first page, says, on June 19th, 2025, it says, it has a date of 19/2025, whatever that means. Trump has pardons and tanks. What do you have? Apparently addressed to the judge. Well, the judge typed a response. Dear Mr. or Mrs. Anonymous, alone, I have nothing but my sense of duty. Together, we, the people of the United States, you and me, have our magnificent Constitution. Here's how that works out in a specific case, and then writes his 161 pages, blocking Donald Trump's continued use of immigration law to ban and bar people because they're expressing their First Amendment rights. As he reminds the administration, and as he notes, is as carved in New Hampshire granite in the very courthouse in Massachusetts that he sits in. The First Amendment says the government shall pass or have no law that abridges the First Amendment rights of people. No law whatsoever. And he says, and no law means no law. Particularly, the First Amendment says, as the judge points out, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances. And no law, according to Judge Young, means no law. Now, after he goes through and does all of his analysis of how professors were arrested with basically masked law enforcement for no reason, he then concludes, and after the conclusion, has effectively an after forward he calls justice in the Trump era. I've read thousands of legal opinions in my 35-year career. And I defy anybody to tell me here in comments, if you're a law professor, if you can remember in history a federal judge or any judge writing an after forward effectively to history and to the United States Supreme Court about issues on First Amendment analysis. Let's start with his conclusion. Judge Young, who's already battled with the United States Supreme Court in the last several months, I'll talk about that in a minute. There's been a call and response between Judge Young and Justice Gorsuch about Justice Gorsuch thinking that Judge Young was in defiance of the Supreme Court because he didn't follow in another case one of their one-paragraph emergency orders. Judge Young said, how is that precedent? It's one paragraph. I didn't realize I was supposed to follow that in a wholly unrelated case. And you've been defiant. Well, if they thought that was defiant, wait till they get a load of this opinion. Conclusion. For all of these reasons, this court finds as a fact and concludes as a matter of law that Secretaries Kristi Noem and Marco Rubio and their several agents and subordinates acted in concert to misuse the sweeping powers of their respective offices to target non-citizen pro-Palestinians for deportation, primarily on account of their First Amendment protected political speech. He noted earlier in the opinion, the First Amendment applies to everybody who is legally here. It probably applies to everybody that's illegally here, since you can't pass a law that abridges the status of the person does not define the First Amendment constitutionally protected right. They did so in order to strike fear into similarly situated non-citizen pro-Palestinian individuals, proactively and effectively curbing lawful pro-Palestinian speech and intentionally denying such individuals, including the plaintiffs here, the freedom of speech that is their right. Moreover, the effect of these targeted deportation proceedings continues unconstitutionally to chill freedom of speech to this day. His position, his findings, is that Trump and the Trump administration and his underlings, Rubio and Noem and others, are using and abusing immigration law and violating the First Amendment speech rights of these permanent residents and other lawful people. We're not even talking about the illegal migrant. That was his conclusion. Now let's go on to Section 5. I call it the afterforward. This court's findings and rulings above resolves phase 1 of these proceedings. The wrong suffered by these plaintiffs is amply established. Bold print. What now? It's on page 148. It is not enough for the court simply to determine that the plaintiff's First Amendment constitutional rights have been violated. The Constitution is not self-effectuating. You got to do something about it. There must be a prospect of an effective remedy. We call it redressability. The reason is the rapidly changing nature of the executive branch under Article 2 of the Constitution makes coming up with redress difficult. And while he is properly not now a defendant in these proceedings, I'm talking to you, Trump, effectively, the nature of our president himself is actually part of these proceedings. It is appropriate, therefore, briefly to address each of these concerns and then limn the constraints that properly must govern the remedy phase of these proceedings. He's not ready for remedy, but he wants you to know where he's thinking, what his thinkings are. In other proceedings involving the Trump administration, this court has already set forth its understanding of what may be called the unitary president. That is the belief by the MAGA 6 on the Supreme Court, which really came out of the late 1980s and 1990s, that the presidency, the executive branch, is occupied by one person who controls all of the power there, and all of the agencies and all of the departments report actually to him, and he runs all of those departments, and he can fire whoever he wants. He can set policy for whatever he wants. And nothing can be done to stop him, even though we have something called checks and balances and the co-equal branches of government. Then he turns to President Trump. Here we go. So on page 150, he says, President Donald J. Trump, he seems to be winning. He ignores everything and keeps bullying ahead. Half admiring, half quizzical, a very wise woman, my wife, made this comment about our 47th president in an entirely different context. I quote it here because it so perfectly captures the public persona of Trump. So he's quoting his wife. I love that. 1, he seems to be winning. Triumphalism is the very essence of the Trump brand. Often this is naught but hollow bragging. My perfect administration. Trump was right about everything on his hat. This tends to obscure the very real and sweeping changes President Trump has wrought in the first year in office. He ignores everything. This is indubitably true. The Constitution, our civil laws, regulations, mores, customs, practices, courtesies, all of it. The president simply ignores it all when he takes it into his head to act. A broad swath of our people find this refreshing. President Trump and others may feel it is we're an overly regulated society. Lawyers seem to have a penchant for telling you what you can't do. President Trump simply ignores them. This is not to suggest that he's entirely lawless. He is not. They then went on to wonder, he then goes on to wonder about the immunity decision and its impact. He then turns to, and he keeps bullying on page 153. Whether it's social media, print, or television, President Trump is the master communicator of our time. His speech dominates today's American idiom. Indeed, it may be said to define it. It is triumphal, transactional, imperative, bellicose, and coarse. It seeks to persuade, not through marshaling data or driven evidence or science or moral suasion, but through power. While the president naturally seeks warm cheering and gladsome welcoming acceptance of his views, in the real world, he'll settle for sullen silence and obedience. He recognizes there are legislative and judicial branches to our government, co-equal even to a unitary president. He meets dissent from his orders in those other two branches by demonizing and disparaging the speakers, sometimes descending to personal vitriol. By the way, this will all be posted for you to read, or I think it's required reading in Legal AF Substack. He then goes through retribution. Everything above in the section is necessary to frame this president and his relationship with the First Amendment and with retribution. He then catalogs the retribution against law firms, against higher education, and against the media. He ends it this way. No order, this is on page 159, no order entered by this court shall materially interfere with defendant public officials and their agents' abilities to properly enforce the laws passed by Congress. To this delicate task, the court will turn in the remedy phase. And then he quotes, freedom is a fragile thing, and it's never more than one generation away from extinction. It is not ours by way of inheritance. It must be fought for and defended constantly by each generation, for it comes only once to a people. President Ronald Reagan inaugural address as governor of the state of California, who nominated this Judge William Young to the bench. Is he correct? And then he typed at the bottom under his signature of William G. Young, he wrote, I hope you found this helpful. This is the response to the postcard. I hope you found my 161 pages helpful. Thanks for writing. It shows you care. You should. Sincerely and respectfully, Bill Young. P.S. The next time you're in Boston, the postmark on the card was from Philadelphia, stop in at the courthouse and watch your fellow citizens sitting as jurors reach out for justice. It is here and in courthouses just like this, both state and federal, spread throughout our land, that our Constitution is most vibrantly alive, for it is well said that where a jury sits, there burns the lamp of liberty. Enough said. Thanks for being here on Legal AF and the MeidasTouch Network. Slide over to MeidasTouch and hit the subscribe button. You can do the same thing on Legal AF YouTube. Come over to Legal AF Substack, where I will post this poignant reminder of what our constitutional republic should be all about. I'm Michael Popak. Thanks for listening. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.